of two topics. One is the judicial activism, another is about the contempt of court. Okay. So, both will be discussed, and then I may be picking up some questions also. So, first of all, when we talk about the judicial activism, see, the idea behind this concept of judicial activism is judiciary, if any organ. So, after after we discuss on our public interest litigation properly, you will understand it better, but still judicial activism is in a judiciary taking an taking a proactive stand. So, activism, any activist, we can say a proactive, not a reactionary situation, a proactive stand, taking taking some extra steps, doing something extra beyond their call of duty. That is the meaning of this activism. See, suppose you talk about an activist, a social activist. So, a person who is willing to work beyond their personal requirement for the society. If they are doing something, we call such people as an activist, political activist. Politically, they are beyond their self. I mean, that is what originally the meaning of an activist. Okay. The same thing here, a proactive, so the judiciary coming into the role of an activist, doing something beyond their call of duty, doing beyond their judiciary's rights or powers. So, that is where the concept of judicial activism will come into picture, and in fact, judicial activism phase was between 1980s till 2015-16 jo bhi hai. Okay, we can say at least 15 to 2017-18 jo bhi hai, we will say, I mean, this is a time when judiciary took an activist role, a proactive role. They have taken some steps much beyond their call of duty to support the poor and the needy. So, that is where the activism came into picture, and this judicial activism, they were able to implement this judicial activism through public interest litigation. Many a times, public interest litigations gave an opportunity to the judiciary to come up with an activist role. And please remember, this public interest litigation is we have already article 32(1), article 32 brackets 1, it talks about the right of every citizen. Okay, if you are talking about article 32, we can immediately understand. Just hold on, let me just talk about that once, and it's easy. So, article 32(1) says that the right to move the Supreme Court, the remedies for the enforcement of the rights conferred by this part, the right to move the Supreme Court by appropriate proceedings, the right to move the Supreme Court with by appropriate proceedings for the enforcement of the fundamental rights conferred by this constitution, which is guaranteed. Okay. The right to move the Supreme Court is given in article 32(1). And as I mentioned earlier also, this right to move the Supreme Court is given to the citizens or those whose rights are violated, or those whose rights are violated. If a person, and even a non-citizen whose rights are violated, can go to the Supreme Court for enforcement of their rights. So, normally the aggrieved person, the person whose rights are violated, should go to the Supreme Court. But through this concept of public interest litigation, Supreme Court said that any public spirited citizen, Supreme Court insisted in PIL that any public spirited citizen can move the Supreme Court. Any public spirited citizen can move the Supreme Court for the enforcement of the rights of those people whose rights are violated. And that itself is a judicial activism. That is something beyond what is mentioned in the constitution. Article 32(1) talks about the right to move the Supreme Court, and it is understood, it is generally understood that this right to move the Supreme Court is available only to those whose fundamental rights are infringed. But now Supreme Court has given a very liberal interpretation, liberal meaning to this, and said that any is a dynamic approach, any public spirited citizen or any public spirited person can approach the Supreme Court on behalf of those people. So, Supreme Court took an activist role, a proactive role, and allowed others who are interested and who are worried about the rights of the people, they can also move the Supreme Court. So, this activism started from there, and this judicial activism has resulted in so many famous judgments, this through PIL. So, through PIL, the judiciary has come up with some wonderful judgments, and right from the that Hussainara cartoon case, where the under trials, more than 40,000 under trials were released. That was in 1979. Then subsequently, a series of cases on child labor, environmental protection, pollution free, the right to have pollution free air and water, bonded labor, exploitation of women in the what you call their care homes, a series of them. So, all these have ultimately led to, I mean, that is where we talked about judicial activism, where judiciary went out of their way to support, judiciary went out of the way to help the people who were in need. Judiciary could have easily said, this is not my work, but they did not stop there and they went and helped. Remember, when the the corona lockdown started, when millions of people or thousands and lakhs of people, when they are walking back, when the initial PIL came in front of the judiciary refused to accept the case. Judiciary simply ignored and said that it is not my business, it is not our business type. But lot of criticism came and judiciary then took up the matter subsequently. So, earlier that was not the case, judiciary was more than willing to accept such cases, and they took a very proactive stand. And in activism, naturally, there is always a fear of conflict. What is the conflict? See, we have three organs. We have the legislature, we have the executive, and we have the judiciary. They are all equally powerful or equally important, and all the three have its own role to play. But over the years, what we have seen, the executive and the legislature have failed to do their duty, and people are frustrated. And because of the failure of the executive and the legislature in doing their duty, the public, the citizens are forced to go to the Supreme Court, and the court is asking and even ordering and using that mandamus, the writ of mandamus. Using the writ of mandamus, Supreme Court is asking the public executive, the public officer or the public authority to do their duty. So, naturally, judicial activism can lead to conflict between these organs of the state, absolutely no doubt regarding that. But Supreme Court's logic at that time was that even if this is going to have some conflict with the executive, the rights of the people are protected because of my judicial activism or my activism. Because of the proactive step taken by the judiciary, the rights of the people are protected, their fundamental rights are taken care automatically. So, that way Supreme Court is not doing anything wrong. There is a failure on the part of executive, there is a failure on the part of the legislature. That is why the people, the citizens, the ordinary citizens had to go to the court, and the court, if the court also refused to listen to the cases, then it becomes quite pathetic, it becomes very sad, and then the ordinary citizens have no choice to go. If the court is listening only what the government is saying, this is what I always insisted in the many classes, the previous class I told, in many instances I said this. This is the problem with the judiciary right now. See, we have seen we have seen various aspects of our politics, the way things work. See, in 1970s, during the peak of Indira Gandhi's power, she also tried to silence and control the judiciary. Many instances took place, and the judiciary, and then even the national emergency was imposed during that time. It was quite easy at that time because the constitutional provision for imposing national emergency was very easy. We will be studying, I will be talking about national emergency, article 352, how to impose everything I will be teaching you. But at the time when even the national emergency was imposed and when many laws were changed, judiciary by and large accepted the position of the government. And over the years, since then judiciary got a free hand, or rather judiciary broke out from that shackles in 1980s and 90s and early in the first decade of this century. Definitely, though, at least for the next 35 years between 1980 to 2015, judiciary acted very independently. They were totally independent. They were not influenced by the government. They did not mince words against the government, criticized, even abused. And many times I personally felt during that time that judiciary is going overboard. They are not, not even, willing to even admit that, they cannot be abusing the executive the way they were abusing at that time, and they were very harsh on the executive. And judiciary was really, the people and the executives were literally afraid of the judiciary. What will they speak next? That was the situation. See, when you look at even in Indira Gandhi's time, I used to say, we have three pillars of democracy. The three pillars are the executive, the legislature and the judiciary. All are equally powerful and equally important. All the three have different functions. The fourth pillar of democracy, we say it is the press, the independent press outside. Now you know what is happening to the press. So these judiciary, and it depends upon the personalities. Please remember, during the time of Pandit Nehru, our first Prime Minister, till 1964, it was the golden era of the legislature, because Pandit Nehru had great faith in the legislature, and he had great faith in the parliamentary democracy. Every decision taken was through parliament, and the parliamentary debates and discussion he used to participate. Even if there is a criticism of his government, even if there is a personal attack on him, he never got angry. He used to listen, and he used to reply, he used to participate in the debate, he used to sit through the whole debates. And we can say that the first phase of our democracy was the golden era of parliamentary democracy and the legislature. Then came Indira Gandhi and Rajiv Gandhi. They had less faith in the legislature. It was the golden era of the executive. The executive means the power in the hands of the executive, less communication to the legislature, less debate in the legislature. Legislature was used by the executive for furthering their interests. Even judiciary by and large accepted that argument, and it was the time of all powerful executive. Then came 1990s onwards, after the death of Rajiv Gandhi and the coalition government, P.V. Narasimha Rao government, and then the NDA government, the Vajpayee government, then Manmohan Singh government, all in 90s. That is the time when judiciary broke free from all these, and they declared themselves, they started coming out with more and more PILs and judicial activism, and they even took over the responsibility of appointing the judges. We will be talking about the appointment of judges in judiciary. I will be elaborately talking about that. In that, judiciary by themselves in 1994, the judges declared that they will appoint, the Chief Justice of India will decide who should be appointed as a new judge in the Supreme Court or in the High Courts. They took over. The power of the executive was taken away, and they themselves, the collegium system came into being. Collegium system. And since 1990s, it was the era of judiciary, or rather, they had an upper hand over both the executive and the legislature, and the judiciary was dreaded, and they used to pronounce judgment. They were very harsh, they used to abuse, they used to scold. That was the situation as far as the judiciary was concerned. So this was the peak of the judicial activism also between 1990, it started in 1980s, But by 1990s, it started exploding, and the judiciary became so powerful, and the whole executive, the whole legislature started fearing. So that is the peak of the judicial activism. But then, what has happened right now, as we know very well, this is a time of, after Prime Minister Modi came to power in 2014, then he even tried to control the appointment of the judges by creating the Judicial Appointment Commission, National Judicial Appointment Commission. He created, or a constitutional amendment was made, NJAC was passed or created. But that National Judicial Appointment Commission was struck down by the Supreme Court in 2015 as a desperate attempt, and ensured that collegium system continues in the appointment of the judges. We will be talking about that. But subsequently, over the years, slowly the judiciary started succumbing to pressure because of the all powerful Prime Minister we have, where every power, all the powers are concentrated in the PMO. They started influencing even the judges to a great extent, and one by one, judiciary started giving judgments in favor of the government, and one by one these judges started accepting plum posts after retirement, including the former Chief Justice, I already told Mr. Gogoi, accepting a Rajya Sabha seat, which is unprecedented in the history. I mean, very rarely it has happened, and that too, you retire and within a few months you are getting appointed or getting this plum post, which is unprecedented, we can say. There are earlier judges also, Chief Justices joined the party, Congress party and all. Rangnan Mishra, when the Chief Justice at that time, he subsequently joined the party. That is okay. There are people, I am not denying it. But the way things are going on, the way the judiciary started, keeping quiet on many things, many pressing issues of the problems of the country, and the best example I would like to give, where judiciary is getting silenced these days. When the Citizenship Amendment Act protests were going on, when the police excesses took place, people went to the Supreme Court thinking that the Supreme Court will support, because brutality, police brutality on the students. Supreme Court simply kept quiet and said, Supreme Court said they will not interfere until the protests are over. This kind of a stand we have never heard in our history, or at least in the last 35-40 years. After judicial activism began, we never heard this kind of a step. Or when, in Kashmir, when Article 370 was abrogated, Supreme Court refused to accept, see, there was a constitutional change. Some of the political parties and the politicians of Jammu and Kashmir approached the Supreme Court related to the constitutional validity of the changes made after August 5th, 2019. But again, Supreme Court took a very, casual approach, or I will say a very slow approach. This case is yet to be heard properly. There are a series of constitutional questions involved in the abrogation of Article 370 and the split of the Jammu and Kashmir into two parts and into two union territories, or conversion of Jammu and Kashmir from a state to a union territory. So many questions. Supreme Court has simply refused. Even in the implementation, after cancellation of the internet connectivity in Jammu and Kashmir, Supreme Court has given an order. Even in that order, they refused to implement the order. They simply said, right to have internet is a fundamental right under Article 19. But at the same time, Supreme Court did not give any remedial measures. There should have been a timetable, there should have been a time frame for the executive to be implementing it. But nothing of that sort happened. So, this judicial activism has over the years have slipped into judicial inactivism in the last couple of years, we can safely say. At least in the last 2-3 years, slowly, step by step, we are seeing a more dormant, a more docile and very sensitive to criticism. You see, Prashant Bhushan, Advocate Prashant Bhushan said something, or rather he tweeted something. We did not tweet anything extraordinary, anything new, which is said by many other judges. It was said by many former Chief Justices of the country about the corruption in the judiciary. And many, and in fact even what was said by Prashant Bhushan was no different from what was said by the 4 rebel judges last year. Even then, a contempt of court proceeding started against Advocate Prashant Bhushan, and the way things have gone. When Corona time, no normal hearing is going on. Prashant Bhushan is not going away at all. He is an activist. He is there in India. He is moving around in our streets. Supreme Court found enough time during the Corona time, when there is no normal proceedings are going on, when there is no normal cases taken up. Even during that time, Supreme Court found enough time to start the contempt of court proceedings against Prashant Bhushan and even to punish him. So, the judiciary has, I believe, the judiciary has completed a one full circle. In early 1970s, or rather, by mid 1970s, when during the emergency time, when judiciary by and large towed the government line, then became super active, and judiciary became the dreaded organ of the state, where the executive and the legislature had a very tough time about the behavior, and the judgments were so harsh on the executive. But over the years, slowly by 2020, we can safely say that judiciary has from activism to some sort of inactivism. 2-3 cases I already told. The way Supreme Court has not taken any action on Article 370 till now, not even heard the case properly till now. They are not even willing to listen to that problems of the people there, number one. Number two, in the Citizenship Amendment Act, when the police excesses took place, when the police lathi charged the people, the students in Jamia Millia and all, again, people went to the Supreme Court immediately, thinking that Supreme Court will give some relief or admonish the police. Nothing happened. Supreme Court was always on the side of the police. In many of those, UAPA cases, and even those cases filed by the previous Maharashtra government against the social activists, even today, most of these activists are not able to get bail, and they are mercilessly persecuted only because they have questioned the government, and they were all declared as anti-national elements, even though many of them are professors in Delhi University and other universities, simple, normal social activists. They are all arrested and sent to jail in various preventive detention acts. Supreme Court has refused to give any relief to them. And during the this Corona, that lockdown, and when the people were walking back, when people approach the Supreme Court asking Supreme Court to give some relief to these rights of the people, the fundamental right of the people are involved in it. When the people's right to food and right to livelihood and many inactions of the government were questioned, again Supreme Court simply refused to take up any case. So, there are many instances of Supreme Court towing a government line, and in any issue, whether it is adjusted gross revenue issue of the telecom companies, Supreme Court is taking generally the government stand. Whatever the government is saying, even IIT JEE exam case, whatever government said, Supreme Court is saying that is final. So, if Supreme Court has to only certify and give authorization to the government position, then the very concept of judicial review and the judicial activism and everything is lost in the process. So, in general, let me just remind you, judicial activism was a great tool, even though there were some extraordinary instances where judiciary has gone overboard and it became an over-activism, or what I will say judicial overreach. There used to be some examples, but still that we used to adjust. Why? Because in 90% of the cases, when our voices are not heard or when our rights are violated, judiciary came to our rescue. But today, situation is slightly different. Judiciary is not coming to the rescue of the people in many instances. Judiciary is taking, the statements given by the executive on the face value and pronouncing judgment based on the executive stand, not on the basis of an independent view taken by the judiciary. There are so many court monitored cases earlier. Now judiciary is not taking, even even the Rafael case, you know, there are serious allegations where there judiciary refused to even inquire about that. I am not saying these allegations are true. In the Rafael case, you know, what best we expected or what minimum we expected was that Supreme Court would have been, they should have gone for a court monitored inquiry. If everything is clean, if everything is correct, what is there to fear about that? But that is not the case. Even the election commission in the paper trail which is there, the VVPAT, opposition went to the court requesting them to count the VVPAT. Supreme Court said no, no need to count. See, this kind of a stand, when you know, when such a massive election process has taken place, months together campaign took place, and opposition even demanded that let us count the VVPAT, or wherever the VVPAT machines are used, please count it and ensure, then only the final verdict should be given, just to ensure that the VVPAT machine number and you know, the actual electronic voting machine number should be same as far as the people who voted. Even that was refused by the Supreme Court. So there were so many instances where Supreme Court is only towing the government view and the government line. No independent view is taken. And then judges are getting appointed, the retired judges are getting plum posts and appointments. That is where the judicial activism has moved away from activism to inactivism. That is my argument in this. So it is a debatable issue, but when you see more and more judgments, when you see and even in the, you know, in some of these we have seen this Scheduled Caste and Scheduled Tribe Atrocities Act, Amendment Act came. First Supreme Court said, I mean, you know, the SC/ST Atrocities Act is unconstitutional and there should be, you know, some mechanism for no automatic arrest of the person who are accused of doing the atrocity. Then the amendment came, and the moment amendment came, Supreme Court now it says whatever the government said is final. So they have completely overturned their earlier position even 1 year before what they said. They are not willing to even stand on that, and they completely overturn. So there are, you can find n number of cases like this, where judiciary is becoming very lenient towards the executive, and this is not good for democracy. Judiciary should act as an independent. Judiciary, the checks and balances, that is where the checks and balances will come into picture. Executive can take a step, but judiciary can declare that step unconstitutional based on the constitutional propriety. But that checks and balance is missing in the system right now, and that is where I would like to say that judicial activism has you know, gone into some sort of judicial inactivism. This is definitely a worrying factor. Judiciary cannot and should not be a spokesperson of the government. Judiciary should independently review and verify and question the government. That is where you know, that is what we want from the judiciary to do. Okay. So that is about the judicial activism concept. And inactivism, I said, this is what I am talking of late, last couple of years, judiciary definitely is acting, or rather it is moving a bit of inactivity from the judiciary. That is what it is generally felt. Now, you know, another topic which I wanted to discuss today is about the contempt of court. What do you mean by contempt of court, and what is the rationale for this provision? All these things I would like to discuss. The contempt of court is a concept that seeks to protect judicial institutions from motivated attack. So what is the concept? The concept is to protect the judicial institutions, from motivated attacks. From motivated attacks, unwarranted criticism, unwarranted criticisms, and as a legal mechanism, I mean, this contempt of court to punish those who lower the authority. Okay. So, this is a legal, contempt of court is a legal mechanism to punish who lower the authority and dignity of the court, who lower the authority and dignity of the court. So, now it was in news recently, that is only because that is the against the advocate and the activist Prashant Bhushan, because he made he had two tweets against the judiciary, one about the corruption, one about the Chief Justice who was riding a bike without a helmet and without mask, okay, whatever it is. So, now the question is how this contempt of court concept came into being, that we got it from the British system. So, the origin of contempt of court, this origin from British system, and it is several centuries old, and the idea it came from the to protect the judicial power of the king, to protect judicial power of the king, to protect the judicial power of the king. And because initially the judge, the king himself was the judge also, and later by a panel of judges who acted in his name, again they wanted to protect the the king and the judges from any any unwanted criticism or violation of their violation of their judgments. So, violating the judge's order was considered as a challenge to the judge or the king himself. So, this contempt of court was mainly on the issues related to violation of the judgment. To protect the king's order or the judge's order at that time. So, so that any disobedience to the judges or obstruction of the implementation of their directives, disobedience I already said, or comments and action that showed disrespect towards them came to be punishable. So, any disrespect to the judiciary became punishable in Britain. So, that is how it started. And so, it was there right from the, because since we had the British, we inherited the British system, right from the British time we had this concept of contempt of court. Many even princely states implemented similar things, and when constitution was adopted, we had article 129, we will be studying in judiciary, where it conferred on Supreme Court the power of the punishment for contempt. Okay. So, the power of the judiciary to punish, okay, to punish any contempt of court, okay, to punish anyone who indulge in the contempt of court. Similarly, article 215 deals with the power of the High Court to punish a person who indulges in contempt of court. So, that is 215 in the High Courts. High Courts have similar power. 129, the Supreme Court has this power. So, 215 for the High Courts. And similarly, also based on this article 129 and 215, in 1971, the Contempt of Court Act was passed. Okay. In 1971, the Contempt of Court Act was passed. It gave a statutory backing through a rule book. What can be the exact punishment? See, the court can punish, it was mentioned, but what kind of punishment can be given? A law was passed in 1971. Contempt of Court an act was passed in 1971, again to protect the dignity and integrity of the court, to prevent the court from being criticized unnecessarily, and to ensure that the court orders are followed properly. That is how this contempt of court idea came, because if the executive themselves violate, what will happen? Then the court should be able to punish them. If the executives are not implementing the court order, a contempt of court proceeding should start. So, there are two types of contempt of court: a civil contempt and a criminal contempt. Okay. So, there are two types of contempt of court cases. One is the civil contempt of court, and the other is known as the criminal contempt of court. So, a civil contempt is very simple. It is committed when someone willfully disobey a court order. Civil contempt is when someone willfully disobey a court order. When someone willfully disobey a court order and or willfully breaches an undertaking given to the court, or willfully breaches an undertaking given to the court. Okay. So, if you are given an undertaking and I will do so many things, and if you violate that, then it becomes a civil contempt of court. Then there is a criminal contempt of court, which is the problem right now. That is what applied to Prashant Bhushan, criminal contempt. So, this criminal contempt is more complex. It has three forms: one, words written or spoken, signs or action that scandalize or tend to scandalize or lower the authority of any court. Okay. So, authority of any court. So, first is the words, number one, the words spoken or written, or signs and actions that scandalize, words, signs, comma, actions that scandalize, or tend to scandalize or lower the authority of, scandalize or lower the authority of any court. Okay. The words, signs, actions that scandalize or lowers the authority of any court. So, that is one is criminal contempt of court we are talking. Second is prejudices or interferes with any judicial proceedings. Prejudices or interferes with any judicial proceedings, So, if you are trying to block or prevent or interfere in any judicial proceeding, and number three, interferes with or obstructs the administration of justice, interferes, if you are preventing a court order from getting implemented, interferes or obstructs the administration of justice. Interferes or obstructs the administration of justice, all the three will come under the criminal contempt of court. So, first is words written or spoken, signs, actions that scandalizes or lowers the authority of any court. Then prejudices or interferes with the judicial proceeding, or interferes or obstructs the administration of justice. So, Prashant Bhushan is accused of scandalizing the court. Prashant Bhushan was accused of scandalizing or lower the authority of any court by making those tweets. So, making an allegation against the judiciary or individual judge. So, if you are alleging that judiciary is corrupt, okay, if you allege that Prashant Bhushan said judiciary is corrupt, or making any allegation against an individual judge attributing motives to judgment. If a judgment is given and if you try to say that this judgment is because of XYZ, attributing motives to the judgment and the judicial functioning, and any attack on the conduct of the judges are normally considered matter that scandalize the judiciary. So, if you are attributing motives to the judgment, or if you are making allegations against judiciary, or accusing, or rather you are attributing motives to the judgment and the judicial functioning, or attacking the conduct of any judge. See, now he attacked the conduct of the Chief Justice of India, especially when he drove that bike without helmet and without mask, attacking the conduct of the judge. So, it has amounted to scandalizing the judiciary. See, the funny thing is, the allegation against judiciary is not said by him, it is said by many former Chief Justices, many retired judges. So, you cannot say that Prashant Bhushan invented this idea that there is corruption in judiciary. Then he attacked the conduct of the judge. See, our Chief Justice definitely violated all the laws. He violated the law that you cannot drive or ride a bike without helmet. And when there is clear-cut instruction in Delhi that you cannot move around in public place without mask, and crores of rupees have already been collected by Delhi government already as fine from public when they have moved around without mask. What is harm in that? He said it, and now that has been treated as scandalizing the judiciary by these judges. And the rationale of this provision is that the court must be protected from such attacks that can lower the authority, defame its public image. It lowers the authority or defame its public image, or make the public lose faith in the impartiality of the judges. Then only we should be taking such action. But Prashant Bhushan, being an activist, we know about him for many years. Even his father, Shanti Bhushan, they fought against emergency, the excesses of Indira Gandhi, many things happened. So, Prashant Bhushan has a wonderful track record. He is known for his activism, and even in the National Judicial Appointment Commission, where judiciary felt that their authority is going to be weakened by this National Judicial Appointment Commission passed by the Parliament during 2015 or 2014, in the first months of Prime Minister Modi's power. Prashant Bhushan was the advocate who filed a case in Supreme Court against National Judicial Appointment Commission, and Prashant Bhushan helped judiciary in that case, and the judiciary gave a judgment saying that National Judicial Appointment Commission is unconstitutional. So, there are many instances where Prashant Bhushan came for the rescue and stood for the judiciary. But at the same time, he is an independent man, he is a, he has his own thinking, and he is a fearless person, no doubt regarding this. He questions wherever there is injustice, that is his style. He was even part of our anti-corruption movement against the previous UPA government. He was part of the Aam Aadmi Party, then he went out of it because he did not like the way Kejriwal and company conducted the whole thing. So, there are so many things. So, Prashant Bhushan's track record we know. He is not a suddenly emerged anti-corruption crusader. He is there for decades, his family, his father, all of them fought. So, they have a wonderful track record. So, now you are saying if the judiciary became so emotional, and when they said that this has scandalized the court, I think it is too much. See, that means judiciary is not, they are becoming, I will say, too sensitive to criticism. Judiciary has become too sensitive to criticism. Judiciary should have ignored his statement. Why give this so much publicity to Prashant Bhushan? That is not required. And they cannot be sensitive like this. They were oversensitive. And in the process, so much of criticism against judiciary, the faith in the judiciary has definitely gone down with this kind of a action by the judges. And it became so counterproductive. It did not enhance the image of the judiciary. And in the process, it has definitely lowered the dignity. The action of the Supreme Court has lowered the dignity of the Supreme Court. That is what I would like to say. So, this contempt of court proceeding against the Prashant Bhushan was unwarranted. He did not make any specific allegation, or he did not scandalize the court in any way. He said certain things which is already said by many former judges, and even our Attorney General K.K. Venugopal himself accepted that he did not say anything new and different which is unknown to us. It is the same thing which is said by many other judges earlier, and why are you trying to punish? And even some of the allegations made by him about the democracy and the Supreme Court, the value is going to go down. This was said by even the four rebel judges at that time, including Gogoi, who was a rebel judge at that time. They have said the similar things, and no action was taken by the judiciary at that time. So, anyway, so this contempt of court was unnecessary. This is a punishment for contempt of court, simple imprisonment for a term up to 6 months or a fine up to 2,000 rupees. Now, but in this Prashant Bhushan case, finally, because of the public pressure, because of the public backlash, Supreme Court found a way, punishment of 1 rupee as fine or 3 months of jail. If you do not want to pay that 1 rupee, you go for 3 months jail and 3 years of he will be barred from practicing. So, naturally, Prashant Bhushan should not be barred from practicing, because he is such an activist. We have some hope even today in the whole system because of people like him who are fighting for on behalf of the rest of the country. Right against, he is fighting for the rights, he is fighting against authority. Authoritarianism and so many things which are going on. So, anyway, so that is how this contempt of court things came. And what is not contempt, any fair and accurate reporting of judicial proceeding will not amount to contempt of court. And also, Supreme Court, in the we have amended the contempt of court case in 2006, and in 2006 it was added that the truth, to introduce truth as a valid defense, if it is to be published, if it is in public interest and invoke a bona fide manner or other, if you are 100% true, and even if it is scandalous to the court, or if it is lowering the dignity of the court, truth as a defense, you can stand by it. You can say, I said the truth and I have evidence for the truth, and because of that truth, if your dignity got lowered, we can't help. So, truth is a defense. Please remember, truth is a defense in contempt of court cases. Okay, these days truth is a defense. Anyway, so that is about the contempt of court, and it should have been avoided. It is not in the good taste, because people in power should be magnanimous in criticism. They can come up with their arguments, they can give their version, no doubt regarding this. But anybody and everyone who says anything against the impartiality or anything should be punished is not the right way. And moreover, the king, this contempt of court and all started during the king's time when there was no democracy. In democracy, criticism, questioning, and low popularity or less popularity, all those things are quite normal, and we should be accepting it rather than trying to silence it. So, this shows the authoritarian behavior of the judiciary. Judiciary is, in Supreme Court is supreme, but they are not above law. They are not above criticism. If they make mistakes, if the criticisms are there, they should acknowledge and try to improve their performance rather than questioning and silencing the critics. So, that is about this contempt of court. Now, let me pick up some questions. Sir, there are some people who only ask questions. I don't know whether you are studying properly. Those who ask questions should study also, your performance should be similar. Okay, every day I am seeing almost similar names, that is why I am quoting. So, sir, what should be the judicial stand on the current environment impact assessment 2020 and environment policy, as we have been consistently degrading our environment standards as per the environment performance index and all. Now, again, now let us hope that judiciary will come up and stand up and say that this whatever environment impact assessment 2020 proceedings are definitely against the spirit, and it is helping in degrading the environment only. Supreme Court should strike it down, but I don't know whether Supreme Court will do or not. We hope. Also, if there are 6 points of criticism of the Constituent Assembly, should we write all the 6 in answer? Because see, if 6 points are there, it is not that all 6 points should be elaborated, but maybe you elaborate 3 or 4 points and the last 2 maybe in one sentence, or last 3 in one sentence maybe. So, that is how we have to accommodate. Tell the examiner that I know it, but because of the lack of space I am not explaining everything. Okay. So, anyway, so that is how normally we suggest. Then another question Ayush is asking, one second. So, Ayush is asking, sir, do we have to remember exact punishment assigned by acts like 3-year imprisonment, some of the important ones? Okay. Then you need not remember all the exact punishment, but sometimes important one, famous ones, try to remember. Rohit, sir, in one of the classes it was said that receipts or to the Consolidated Fund of India does not need the approval of the Parliament. But I do not think we have said Article 265, Mani should have definitely said any money coming into the Consolidated Fund of India require the permission of the Parliament, and any money taken out, Article 266, again it requires the permission of the Parliament. So, I do not know whether it was said that receipts does not require parliamentary permission. I do not think we have said it. If at all it is said, maybe by slip of tongue. It is very clear, Article 265, any money collected or any money coming into Consolidated Fund of India requires the permission of the Parliament, and any money taken out, Article 266, again requires the permission of the Parliament. Shahrukh Ali is asking, sir, whether reservation was provided to bring equality or in demand of separate electorate. See, separate electorate and all, it came at that time, but the main aim, that is why we added in Article 14, please do not forget this. Article 14, equality before law and equal protection of laws. Why equal protection of laws? And why reservation is an exception to Article 15 or 16? All are related to equality. So, definitely it was to bring in equality and nothing else. Of course, if the people are not getting, if scheduled caste, scheduled tribe communities are not getting any viable solution, they may be asking separate electorate or something like that. That is another issue. But ideally or originally, the idea is to bring everybody equal. Maria is asking, sir, the doubt is not on today's topic. Please pardon. Santali, okay, is Santali language against the natural law of one should not be his own judge. And then I could not get it here. Achha, Santara, is it because of that natural law? One should not be on his own judge. Here in this case, the person is giving himself a punishment of that person's sin. And you are talking about Santara, I am sure. Okay, so what you typed is wrong. Anyway, Santara. So, see, that is different. Now we are saying you can be a judge of your own cause in the sense if you yourself is the party and you are the judge, and if it's not affecting others, you can take a decision on yourself. See, self decision making. You decide on yourself. But when we say natural justice is about if others are involved, you did something or other and you did not do anything, you are trying to punish a third party, but you have a vested interest in that, then that is a violation of natural justice. See, if I am the judge and I am also the victim and I want to punish you, then it is wrong. If I am the victim, somebody else should be the judge. Or if I am the judge, I should not have anything to do with that case. I should be neutral and independent, and I should be able to act in an independent manner. That is the meaning of natural justice. Okay. So, Santara case, you at the old age, see, why do you go for some fast or Lent season in Christianity or Ramzan, or when we go for fasting? Why? Self purification, is it not? So, we have a sense of what is to be done to improve our mental strength, improve our character. That is what Santara is also, not to confuse with the natural justice. Natural justice is about something else. Natural justice is about if you are a judge, then you should not be a party to that case, because I have a right not to be judged by a person who has a vested interest in the case. Suppose you are going to the court against your neighbor. Now, in the court you realize that the judge is a relative of your neighbor. What will happen? You will lose all faith in the judge, because you know that that judge will give verdict only in favor of your neighbor, because the neighbor and the judge, they are relatives. Or you have a case against somebody, your neighbor, and finally when you went to the court, you realize that the judge and the neighbor is the girlfriend of the judge. Kya hoga? You will not get justice. That is what natural justice we are talking. Okay. Anyway, Saurav Kumar is asking, is judicial activism really give judicial restraint? See, that is what I am saying. Activism will not be, judicial activism should be restrained if they go overboard. But now what is happening? Judicial activism, as they themselves stopped activist role has been stopped. They are more like docile, and they are gone into some sort of coma. That is what I will say. So, my volume is very low. My volume is low, you have to increase your volume. Okay. So, Ridyam is asking, sir, please ensure to add new prelim test on polity topics. And we are adding, I mean, every day we are adding. I mean, I don't know why this question is coming, because every day prelim questions are coming. Anyway, Chirag, Civil Rights Protection Act protects an individual from ragging. See, Civil Rights Protection Act is something to do with the what you call discrimination, untouchability. Ragging, anti-ragging acts are there. Okay, so you need not confuse about that. A separate law against ragging. Then another question, Swati is asking, sir, we can't take action against judiciary if judiciary is not working. Yeah, I don't think we can do anything, and that is where the problems are there in many cases. If judiciary themselves fail, if judiciary is not taking up the case of Article 370, if judiciary is not taking up and implementing the right of citizen to have internet in Jammu and Kashmir, if judiciary is not taking any action against the executive in the Citizenship Amendment Act protests and the police excess, we have nowhere to go, and that is how we slowly lose faith in the system, which is very, very dangerous. Supreme Court has become the ruling party's puppet. Hinduism might have corrupt them, but hope this tough time will pass one day. See, now let us not openly say this, but definitely judiciary is becoming more lenient toward the ruling party, if you say. I mean, many of the orders are looking like that. So, Kaha Takam is saying this, and we cannot outrightly deny certain points. There are question marks raised in our mind because of the way judiciary is behaving. So, we can't help. Saksham sir, please upload current affairs 13. See, I mean, it should be there. I mean, I will find out once again. Yesterday also I was telling this, and if it is missing, I will ensure we will have all the current affairs magazines in the portal, which you can download. What is the fear behind judiciary from being an independent? See, the fear is, it's not about the fear. Please don't understand. Many times, if you lose your, moral high value, you are more concerned about what you can gain after retirement and all. It may not be the fear. It is the allurement may be the problem right now. See, if you have to be away from your all allurements and all, you need to be morally and mentally very strong. Not many people are able to do. That is where the problem is there right now. It may not be the fear. It may be the prospect after 65, after the retirement. Okay, the post-retirement benefits are, making many a time the judges do too many things. That is the fear among many critics of the judiciary right now. The PIL inserted, it's not inserted in Article 32. Shreya is asking, no mention about PIL, it's a judicial innovation. There is nothing called PIL in our Article 32. But through Article 32, one's broader interpretation, PIL came into picture. So, it is inferred from Article 32(1), we can say. Omkar is asking, sir, I am so disappointed that instead of seeing dates and months on current affairs magazine, it is issue 1 and 2. So, don't worry, and we are changing. I mean, every article we are mentioning in which date is there. Okay, issue 1, 2, 3. Why are you so disappointed about that? I mean, I can't understand. If you are disappointed on this small thing, if you see something else, you will be disappointed and you will commit suicide. So, what is there to disappoint? In every article, we are mentioning which day's article is that. In the month is there, date is there. So, purposefully we did not give the months at that time. Issue 1 means we started in July 2019, and every month, July 20 to next month. Okay, 1 month 20th to next month 20th. That is the cycle of that magazine. For continuity, we have done it, and in the article we have mentioned it is which days or which weeks article is that. Okay, so don't get disappointed on small things. फिर तो तुम्हारा लाइफ में पूरा डिसअपॉइंट नहीं मिलेगा. कल को तुम शादी के टाइम में भी तुम डिसअपॉइंट हो जाएगा. बीवी तुम्हारा बात नहीं सुनता तो तुम डिसअपॉइंट होकर मर जाएगा फिर. Okay, so don't be disappointed like this. Then Shreya is asking, sir, if I got the study material, do we still have to study from the online PDF because many things are missing in the book? So, online PDF material has more information than what is there in the study material, but there is no contradiction between that. The same material is there, the same heading is there, it is by and large the same. Online